Good afternoon, everyone. My name is Mark Stinson. I'm the leader of the Asia Pacific Group here at Fasken, and I'd like to welcome each of you to today's webinar, Towards a Waste-Free Ontario, Electrical and Electronic Equipment Regulation in 2021 and beyond. My primary role today is to introduce our sole presenter, Rosalind Cooper. But before doing that, I'd like to thank Shoka Kai and Mr. Ito for giving us the opportunity to participate today. Fasken has been a member of Shoka Kai for many years, and we look forward to giving future presentations in 2021 and beyond. So introducing Rosalind. Rosalind is one of the leading environmental practitioners in Canada. She's certified by the Law Society of Ontario as a specialist in environmental law, has been named 3 times as the best environmental lawyer in the year by the publication Best Lawyers in Canada. Rosalind has repeatedly recognized by Lexpert as most frequently recommended for environmental law and in the international who's who of environmental lawyers. She has also been named in the Lexpert American Lawyer Guide to the leading 500 lawyers in Canada, in Best Lawyers in Canada for Environmental Law, and in both Chambers Global and Chambers Canada for Environmental Law. Rosalind litigates contaminated land disputes and other environmental matters, defends environmental charges, and is involved in appeals and environmental assessment proceedings before the Environmental Review Tribunal. She has extensive experience advising on all environmental regulatory issues, including exposure to environmental liability, brownfields redevelopment, decommissioning, and remediation of contaminated lands, project development, approvals, and reporting requirements. Rosalind also provides environmental advice in relation to business transactions, such as mergers and acquisitions, the purchase and sale of real estate, and secured lending transactions. She's written numerous articles on a wide range of environmental issues and has spoken at various environmental issues at numerous conferences. She's also listed on the roster of environmental mediators and arbitrators in the Canadian Centre for Environmental Arbitration and Mediation. So without further ado, I'll hand it over to Rosalind to make the presentation, and we will look forward to some questions at the end of her session. Thank you.
Thank you very much, Mark. I appreciate that introduction, and hello to everybody. Before I begin my presentation today, I wanted to make some brief introductory remarks that might be helpful to people. First, I wanted to say that this new regulation, which effectively takes effect on January 1st, 2021, is an extremely technical and highly complex regulation. And so we, of course, cannot cover all aspects of the regulation during this hour seminar that we have today. But I wanted to let people know that we will try and highlight the most significant provisions and focus on those and try and convey the general requirements of the regulation without getting too technical to the extent that's possible. But I did want to emphasize that this is a technical regulation and there's far more that we are not able to present during an hour that is contained within the regulation. The second thing I wanted to mention is that this is a new piece of legislation. And whenever you have a new piece of legislation, it does take a bit of time to sort out some of the issues with the regulation and how it will work in practice. And so I fully expect that come January 1st, 2021, there's going to be some glitches and some issues and some questions of clarification that come up with respect to how this is all going to work. And that's natural and to be expected anytime you have a new regulation in place. And so I think people will just need to be patient as we work through some of those, and also understand that in some cases where it's not completely clear what the intent is in the regulation, that it may take some time to sort that out because we don't have a lot of precedents and many of these questions are coming up for the very first time. And so with that brief introduction, I'm going to begin the presentation. At the end of the presentation, we are going to leave some time for any questions that people may have, and we'll do our best to answer those questions. And again, I emphasize that this is a higher level presentation. It is not intended to do a deep dive into all technical aspects of the regulation, but hopefully by the conclusion, you will have a better sense of what this regulation is all about, what it requires, and what some of the obligations will be on those that are affected by it. So let's start the presentation. My first slide, WEEE to E, is really an indication of the transition that's taking place right now. Many of you know that we've had a waste electrical and electronic equipment program that we've called WEEE that's been operated by the Ontario Electronic Stewardship. And that will be coming to an official end at the end of December. And in its place, we're going to have this new regulation coming into force, which creates an entirely different system and one that we haven't had before. And that new system is based on the concept of individual producer responsibility, which is a concept that's not new globally. It's one that's followed in many jurisdictions, and it's certainly not completely new in Canada either. There are some jurisdictions, certain provinces that have this type of system in place. But Ontario is now also moving to an individual producer responsibility format, which essentially means that the producers of the equipment are the ones that are going to be individually accountable and financially responsible for the collection and reuse and refurbishing and recycling of their products when they're discarded by consumers. And that is a different system that has been in place until now. You'll hear me refer in this presentation to WEEE. That's electrical and electronic equipment, which is what we're using now to term the types of materials that I'm going to be talking about shortly. And the other term you're going to hear me use a lot is the RPRA, or the authority. And that is the regulator that has been designated as having primary responsibility for enforcing the regulation. So that is the authority that will be answering all of the questions, providing the clarification, and that most producers will be corresponding with in the context of this regulation. So the first question most people ask me is, so what does this regulation cover? What is WEEE? So WEEE, electrical and electronic equipment, is equipment that meets the following definition. It has to be designed for use with an electric current. It has to have a voltage of less than 1,000 volts for alternating current and less than 1,500 volts for direct current. It has to weigh no more than 250 kilograms, and it cannot be intended to be used permanently as part of a building or structure. So each piece of electronic equipment that's considered, you have to turn back to this definition and see whether or not it meets the definition in order to know whether or not it's covered by the regulation. It does cover all WEEE that's sold into all sectors. So whether we're talking industrial, commercial, residential, hospitals, whatever sector you might imagine, all sectors are covered under this regulation. And it also includes batteries that might be supplied with WEEE. There's two categories of WEEE. We're only going to talk about one of the two today, but I want you to know that there are two under the regulation. The first that we're going to focus on today, because that's the part that takes effect on January 1st, 2021, is what we call ITTAV. ITTAV is Information Technology, Telecommunications, and Audiovisual. And the second category, which we're not going to talk about today, is lighting. But lighting is also covered by the regulation. And I'm only going to say two words about lighting. And that is that lighting registration for producers and service providers doesn't come into play until November 30, 2022. And the first performance period isn't until January 1st, 2023 to December 31, 2023. So one of the main reasons why we're not going to spend a lot of time focusing on this today is that this aspect of the regulation is not imminent. This does not come into play for a few years. And so our main focus today is going to be on the WEEE that comes into effect on January 1st. And that is the ITTAV. So primary purpose of ITTAV materials relates to presenting, processing, collecting, storing, and communicating information, including sounds and images, recording or reproducing sounds and images. And a lot of people say to me, what does that mean? And I thought I would put up an example, which is from Schedule 1 of the WEEE regulation, which actually sets out some of the items that are included in this definition. And it's typically what you might expect, things like computers and printers, video gaming devices, telephones, cell phones, display devices, radios, stereos, headphones, speakers, and cameras, including security cameras. Also includes video recorders, drones, peripherals and cables used to support function of equipment, technology, and telecommunications, and handheld point of sale terminals or devices, and musical instruments and audio recording equipment. Some of these things, those of you that are familiar with the current regime, will note that they were not included in the existing program. So some things that you have seen in this list are newly regulated items. And so it is important not to presume just because you may be familiar with the previous regime and thought something was covered or not covered, that it will not be covered here. You must check the definition in Schedule 1 because the schedule is much broader than the previous one, and EEE is a very broadly defined term. There are, however, certain excluded items, and I thought I would list those for your benefit as well. They're on this slide, and these EEE items are not covered by the regulation. So some examples include things like cash registers and self-checkout machines, street lights, motor vehicles, children's toys, EEE that falls under the Food and Drug Act, and equipment that's used with respect to marine, military, and aeronautic or space equipment. So there are excluded items, but it is a much broader definition. So the next question I'll get asked after, okay, so what equipment is covered by this EEE regulation is, so what is an ITTAV producer? Do I have to actually worry about this regulation? And so an ITTAV producer has a defined term under the regulation, and I'm going to walk you through it, but I also want to emphasize that this is a hierarchical definition, meaning that if you don't fall or a particular company doesn't exist, then you look down the cascading definition to see if the next party can fall into the definition before you decide who is the person and who is the producer in the context of the particular ITTAV. So the first part of the hierarchy is you look for the brand holder that's resident in Canada. And this is different. It's not just Ontario, but the brand holder resident in Canada. And the term resident refers to having a permanent establishment, and it's the same definition that's included in the Income Tax Act. So if there is a brand holder that's resident in Canada, that is the party that will be the producer for the purposes of the EEE reg. If there's no resident brand holder, then the party that will become the producer is the importer that is resident in Ontario. So that party will then be the producer and have the obligations for the purposes of the reg. If there's no resident importer, then the person that's resident in Ontario that's marketing the EEE item is the party that will be the producer. And the last catch-all is if there's no such resident marketer, then the non-resident marketer will be the producer. It is possible that there would be more than one brand holder resident that might deal with a particular EEE item. And in that case, the regulations state that the party that has the closest nexus, the closest ties to the item that's being produced is the party that will become the producer. But there may be times when the authority will need to be approached to seek some clarification on which party between two different brand holders will be the producer for the purposes of this regulation. So there are some producers that don't need to worry about being governed by this reg, even if they fall within the definition of being a producer. And I have this slide to explain what that might be. So essentially, if a producer's management requirement under the reg, and we're going to talk about what a management requirement is in a bit, is less than 3.5 tons before any reductions based on supply data, then they don't have to register and report to the authority. They don't have to establish a collection and management system and meet a management requirement. And they also don't have to conduct promotion and education requirements. Those three bullets are many of the requirements that exist under the regulation that apply to producers. But if you happen to be one with less than that threshold, you don't need to worry about doing those 3 things. But, and this is important, if you are a producer of WEEE, you must still retain your records relating to the weight of the ITTAV supplied into Ontario, and you must provide it to the authority upon request. So this is an important point for those that look at the requirement and see that they don't meet the threshold. They may think, well, I don't need to worry about this regulation at all. You don't need to worry about it in terms of actually carrying out the obligations. You do need to worry about it in terms of maintaining records to be able to demonstrate to the authorities that you are not caught by the regulation. There are also exemptions when you look at who must comply with the regulation that are based on annual supply thresholds. Those thresholds are rather complex because there's a formula that's provided in the regulation as to how you determine that. And the formula is based on the units that are supplied into Ontario and the weight of the units supplied. And I've set out on this slide how you determine those things, but it's beyond the scope of this presentation to talk in detail about how that formula works because it is quite complex. But the message I want to leave you with is that there are further exemptions available depending on the annual supply of your ITTAV. I want to briefly touch on volunteer organizations. Volunteer organizations is not a new concept in the sphere of waste management. And many of you may be familiar with the concept of a volunteer organization, and that is effectively a party that is not necessarily a producer that's falling within the framework of the definition of producer, but it's an organization that decides that it's going to comply with the regulation in any event. And so a volunteer organization is essentially an ITTAV brand holder that is not resident in Canada, but they nevertheless register with the authority and they enter into a written agreement with the producer in relation to one or more of the responsibilities, such as registration and reporting. And a volunteer organization can take on the registration and reporting responsibilities that producers would otherwise have. But, and this is very important for those of you that decide to enter into agreements with volunteer organizations, the producer always remains responsible for meeting the requirements of the reg. And what I mean by that is that even if you have a commercial arrangement with another party where you have effectively offloaded to that party the requirements for compliance with registration and reporting under the WEEE reg, if that party doesn't do it or doesn't do it correctly, that is not a defense. Ultimately, you still have responsibility for meeting those requirements. So that's something important to note. So if you are a producer, how do you register and what do you do? So all producers were supposed to register on or before November 30th, 2020. If you are a producer, based on the slides that we just went through, and you have not registered, you ought to be contacting the authority fairly quickly to speak to them about registering. The collection and management requirements are the ones that come into force in January, but the registration has already taken place and should be registered. Any producer should be registered, as I said. When you register, you must pay a registry fee as part of the registration process. And the format for registering is effectively a spreadsheet-based form. Those of you that have registered will have seen this. And it includes some of the information that I've listed on this slide. But that information is required in order to be able to register, including, most importantly, the weight of ITTAV that was supplied in 2018. And although I'm not going into detail on this, I would note that many of the calculations and the formulas are based on the year 2018. So that is the year that the regulation has tied itself to at the outset in order to determine weights of materials that qualify as WEEE. So what is a producer agreement? So once registered, a producer can enter into a written agreement with one or more people to carry out all of the producer's requirements and obligations under the regulation, including supplying data and reporting payment of fees. This is important because I expect that there are going to be quite a number of producer agreements out there. Many producers will not want to carry out all of the obligations under this regulation themselves. They are extremely onerous, they're extremely cumbersome, they're extremely detailed. And unless a particular company has enough personnel and enough familiarity with this regulation to essentially, embrace the regulation and the requirements and learn them to be able to carry out all the obligations, I suspect many producers out there will be entering into these commercial agreements to carry out the producer's requirements and obligations. The producer still, as I said earlier, remains responsible and liable for meeting the requirements under the regulation. But at the same time, it is important to include appropriate protection in those agreements in case there is a non-compliance matter. So for example, if under the agreement, there's a failure to submit certain data that's required, or a failure to provide information that needs to be required or to submit it to the authority, you'd want to have some relief provided there in the event that the authority takes issue with you as a producer for being out of compliance. So it is important to ensure that you have appropriate remedies in your contractual arrangements so that if there is an issue or a problem with compliance, even though the obligation with the authority remains with the producer, that there is some recourse available. So service providers have a defined term under the agreement as well. Service providers can be haulers or processors, they can be refurbishers, and it can be producer responsible organizations. They're called PROs under the regulation. All of those parties are service providers under the WEEE regulation. And a PRO, just to be very clear on that, what that is, a PRO is a party that's retained by a producer to arrange the establishment or operation of a collection or management system for ITTAV, and to establish or operate the system on behalf of the producer, and to prepare and submit reports. So these are the parties that producers will be entering into contractual arrangements with, these service providers, who will be doing the work on behalf of the producers to comply with the requirements. And there is a list of PROs that have been registered and approved by the authority that you will find if you go onto the authority's website. So there are a number of companies that have already been blessed as PROs that you can contract with if you so wish. So I want to talk a little bit now about the collection system requirements. So there are different management requirements for small and large ITTAV producers. And the way the regulation works is that it has divided into two categories, ITTAV producers, small and large, and created requirements based on each. So the definition of a small producer is someone who manages more than 3.5 tonnes and less than 700 tonnes of ITTAV materials. A large producer is someone who manages 700 tonnes or more of ITTAV. And it's important to figure out which one of the two you are, because the requirements with respect to collection systems and other requirements will differ depending on whether you are a small or large producer. So I'm going to talk quickly about each just to give you an idea of what the difference is. I know this is starting to get a bit technical, but just going to cover it for you. If you are a large producer, starting Jan 1, 2021, you must establish and operate a collection system for your ITTAV. It is important to note that collection sites can be shared amongst producers, but the amount of sites that you will require depends on the size of the municipality where you operate. So municipality with population of less than 1,000 and less than 500,000, you need one collection site for every 15,000 people. Next level, next category, there's three. Second category, if you have a municipality with population more than 500,000, you need at least 34 collection sites for the first 500,000, and at least one collection site for every 50,000 people or portion thereof after that. And if you have a territorial district with a population greater than 1,000, you just need one collection site. So that's large producers. Small producers have different requirements, which are actually based on the number of retail locations that they have. So with a small producer, in each municipality where they have retail locations, the number of collection sites has to be equal to or greater than 75% of the number of retail locations that market the producer's ITTAV in that municipality. So you effectively take your number of retail locations that you have, and 75% of that number is the number of collection sites that you must have in that municipality. And you do that for every municipality in which you have retail locations. The other option is you do the same as the large producers, where you use the population in the municipality to determine the number of required sites. And it is completely optional for small producers which one of those two means they prefer. So let's turn now to talking a bit about the requirements for sites. So producers have to ensure that consumers can drop off their ITTAV at no charge at each site that's part of their collection system. So that's an important aspect of it. The concept, again, behind this individual producer responsibility scheme is that every single producer is going to make available to consumers a drop-off location for the waste material. And that is a fundamental component of this framework in terms of the way that it operates. And so if the collection site isn't part of a retail location, then it has to accept all ITTAV materials. If the collection site is part of a retail location, then the site has to accept, at a minimum, all ITTAV that are of a similar size and function and fall into that category that's supplied by the producer at that location. So the idea is that if you have a retail location and you're going to operate a collection site as part of the retail location, you have to ensure that that site can accept, at a minimum, it can take more, but at a minimum, the type of ITTAV that's of a certain size and function and is supplied at that particular location. That's a very important aspect of this regulation. And if the collection site isn't part of that retail location, then it has to accept everything. You can't limit it. So the idea is that if a consumer has purchased a particular ITTAV at a certain location, that they ought to be able to return to that location, and they ought to be able to return it at that location, which makes sense in terms of the way this system operates. So the other thing that's very important is that the collection site be readily accessible to the operator or to the public. So the idea is that if a member of the public, a consumer, wishes to return this waste material at a collection site, that they be able to do that during normal business hours. And this is all about accessibility, right? So this is about making things accessible for those that may need to use the system and return things. The collection site has to also accept, at a minimum, up to 50K of ITTAV per day from any person. So if the collection site is not part of a retail location and the collection site accepts more than 50K of ITTAV from a person on a single day, then the operator of the site must record the person's name, contact information, and the weight of ITTAV accepted. This is quite onerous. And so, I point out to you that as you're looking at establishing these collection sites, it's one thing that you have to make sure that you have the ability and the capability to receive up to 50 kilograms per day from any person. But it's interesting that if you end up in a situation where you're willing to accept more than the 50K of ITTAV from any person on a single day, you now have to keep records of who it is and their contact information and the weight of the materials that they've left with you. So that is an important requirement. It's not at that point, if the volume becomes that large, it's not simply just a drop-off location anymore. There's an obligation to actually keep records in terms of what's being left behind. There is a way to decrease collection site requirements whereby producers can actually reduce their collection site requirements. And there's a number of different techniques for producers to be able to do that. So first, curbside collection. You can reduce the number of collection sites that you're required to have by the percentage of residences in that municipality from which the producer collects ITTAV at least 4 times a year. So if you provide for curbside collection, that's a way to reduce your statutory collection site requirements. Mailback programs. This is another technique that's in the regulation to reduce the number of selection or collection sites that are required. You can do that by simply ensuring that you have a mail-back program where consumers can return used ITT AV in the manner supplied or by mail at no charge to the consumer. If you provide that type of mail-back program, you again can reduce the number of collection sites that you're required to have under the regulation, and that's an important way, again, to reduce those requirements. And then the final way to do it is to run events. So basically, a producer can replace the number of collection sites required in a municipality by the number of events that they hold, up to a maximum of 25%, provided that each event is run for at least 4 hours in length and that it accepts ITT-AV. So these are important because for producers that are looking for decreasing and reducing collection site requirements, which are quite onerous as we saw from the previous slide, there is a way to do that by simply engaging in these 3 different methods, looking at curbside collection opportunities, looking at mail-back programs, which for some smaller materials may be very feasible and easy to do, and then looking at these events, bearing in mind again that the events can only reduce up to 25% of your collection requirements, but they are a means by holding these and keeping them open for 4 hours to reduce those collection site requirements. So next topic I want to talk about is management requirements under the regulation. So starting January 1st, 2021, every producer must establish a system for managing used ITT-AV. So what do we mean by that? It means that on that date, there's a requirement for every producer to look at the types of systems that they can create or enter into agreements with to actually deal with the materials that are collected. So part 1 is the collection. We've talked about that. Now we're into how do you manage and what are the obligations on management. So producers have to ensure that all ITT-AV that's picked up from a collection site, regardless of whether it's part of the producer's collection system, is managed within 3 months of the pickup date. This is fairly significant, right? This is ensuring that within 3 months that the materials are collected, that are picked up, that you are managing it and dealing with it. And we're going to talk about what managing and dealing with it is, but that is a time frame that must be followed and is created under the WEEE regulation. Managing means you are either reusing it, you are refurbishing it, or you are processing it. And by processing it, what I mean is it becomes what we call a recovered resource. Now, it is important to look at those 3 techniques, reuse, refurbishing, and processing, as the techniques that you must engage in order to manage materials. That is a requirement under the regulation. And the weight of recovered resources, and we're going to talk about what that means in a minute, can be counted as twice the actual weight if the producer utilizes the services of a refurbisher who's located in Ontario. So I flag this for you because this is very interesting. Essentially, what the government is saying is that if you find a refurbisher whose operations are actually located and do refurbishing within Ontario, our province, that they will allow you to count the weight of the recovered resources, which is a requirement under the reg, as twice the actual weight. And that is quite important because it really puts an emphasis on and encourages companies to look at the possibility of using refurbishers in Ontario, because you'll get twice the value from what you actually find as a recovered resource. I don't want to get into this slide in too much detail because it is very technical again, and I'm trying to avoid too much technicality, but recycling efficiency rate is something that's outlined under the regulation, and it's intended to refer to the weight of resources that are recovered versus the weight that's received by the ITT-AV processor. So the idea is to see, you're bringing in these materials, what are you actually producing out of your recovery? Is your recovery rate effectively 50%, 75%? What is that rate? That's what the recycling efficiency rate is all about. And beginning in 2023, and this is an important point, producers can only use an ITTAV processor for the purposes of meeting their management requirement that has at least 80% RER for ITTAV. So the idea will be that there's going to be a few years where you can use any processor you wish, but after that, the government wants you to only use those that have an 80% RER rate. And the idea again is to, use refurbishers that can ensure really recovery of resources to the maximum extent possible. The first reporting for a verified RER is for the calendar year 2021, and that has to be reported by April 30, 2022. So the government's going to keep track of the RER that is produced by various ITTAV processors. And again, by 2023, they're looking to only use those that have the 80%. Promotion and education. So promotion and education is an important aspect of this regulation. It is an aspect that the government feels is so important that they've actually enshrined it into the regulation. And why? Because when we look back at the history of this regulation and of waste management in the province of Ontario, one of the key messages that have come out of many of the policy reviews and stakeholder consultations has been that people don't understand enough about what you have to do to reduce waste. And there isn't enough education out there. And the view is, who better to do that education and who better to put that responsibility on than the producers of the waste material. And so we see this in other regulations that have come out in Ontario dealing with waste, and it's no different with this regulation. There is an emphasis in the actual regulation on responsibilities of producers with respect to promotion and education. And I thought I would just put in this slide what you need to do from January 1st, 2021 to December 31, 2022, which is the first phase of this program, to give producers an idea of what their obligations are going to be. So first, make reasonable efforts. And if you're wondering why it says reasonable efforts, it's because there was a lot of feedback about how far do you have to go and what do you have to do. So the regulation talks about making reasonable efforts to raise public awareness of the producers' efforts with respect to collection, reduction, reuse, recycling, and recovery of ITTAV, and encourage public participation in those efforts. Now, I always say that when you have some vague terms, and reasonable terms may be vague terms, it gives rise to a lot of questions about how far do you have to go and what do you have to do. But it is clear under the regulation that it is incumbent on producers to look at opportunities to raise public awareness with respect to these activities and to encourage the public to participate in the efforts. The other aspect is to publish and clearly display certain information on their website. So this is what producers are going to have to put on their website. First, the location of each collection site that's part of the producer's collection system. And that is where consumers can actually return the ITTAV at no charge. And they say in the regulation, you can actually link to another website where you have to provide the information. So you can link it to the website that has the information. It doesn't have to be contained on your website, but you must clearly publish the information so people know where the collection system is. Number two, you have to describe the collection services provided by the producer that are available other than at a collection site. So they want to be sure, again, that you are conveying to the public the information about collection services and where they can deposit their materials. And then finally, the other thing they want to ensure that producers will put on their website is they want a description of resource recovery activities that are engaged in by the producer in the course of managing ITTAV. They want producers to publicly communicate all of the information that they have available with respect to resource recovery activities. And again, this is information, it creates awareness, it's promotion and education, and it is an effort to engage the public in these efforts to reduce waste. And so this is an important aspect because it's very easy for the regulator to go on the website of a producer and look to see whether or not these three elements are present and decide that you're in compliance or not in compliance. So these are easy ones for the regulator to find that you haven't met as a producer, but also easy for a producer to fix and make sure they have available on their website. So that's something that will have to be dealt with. And I just want people to be aware of that requirement as well. So performance requirements. This is something that I want to emphasize because there are performance requirements under the regulation. This is not just about promotion and education and collection of materials and refurbishing and reducing. The government wants to know and make sure that there's going to be some efficiencies and some productivity received from all of this, and that there's actually going to be a movement towards the reduction. And some of you may have heard about the government's, efforts and objectives and goals with respect to reduction of waste. They want to have performance measurement as an actual component of this regulation. And indeed, it is a component of the regulation. So what does this mean? So the first performance period that the government will look at for ITTAV management is going to be the period starting January 1st, 2021 to December 31, 2021. And it is interesting, and this is really sort of a phase in for producers. So you're getting a bit of a break the first couple of years. The requirements are best efforts. And I say best efforts in quotes because that's what the regulation says. And the calculation of your performance is going to be based on a baseline of 2018 numbers. And I referred earlier in the presentation to 2018 being that number that is important in terms of looking at what your weight is and what your recoveries are. And so what I wanted to emphasize is in 2022, the best efforts requirement is going to be 55%. And what that means is that you will have to ensure that your performance reaches a target of 55% making best efforts, meaning if you don't achieve it, it's not non-compliance as long as you've made best efforts. And that requirement will apply during 2021 and it will also apply during 2022. And in 2023, it's going to go up to 60% and it's no longer a best efforts requirement. By 2023, the requirement will be enshrined in the regulation and there will be no leeway where you can try and demonstrate that you did everything that you could. It's going to be 60%. 2024, it will move up to 65%. And in 2025, it will move up to 70%. And the idea is to keep moving forward in increments of 5% as you go forward, with a goal eventually being that your performance reaches perfection. And so you are going to get a bit of a break for the first couple of years. You can rely on this best efforts to achieve this 55% target. But it's important to remember that that's only a break for the first couple of years. Then you're into the higher number of 60%, and that number is going to continue going forward. So I've decided to stop a little bit earlier because I got a bit of a message that we have quite a queue of questions in line. And I want to give people an opportunity to answer questions. So I'm going to stop a little bit earlier and turn it over for some questions. And if we get through all of them, I do have much more I'd like to share with you, but let's start with some questions now. And I'm just going to, some of you may have seen on my screen, speaking of electronic equipments and malfunctions, that my battery is going a bit low. So I'm going to try and replug while I turn things back to my partner, Mark, to bring up some questions for us.
Thank you, Roz. The big question here appears to be enforcement. What if you're offside the legislation? What kind of enforcement mechanisms exist in the regs? Okay, so that is an excellent question. And it is one that I get asked a lot about. So under the regulation, there are no enforcement mechanisms. It relies on the statute for enforcement. So you go back to the Circular Economy Act and you go back to the waste reduction legislation itself. And there's 3 different methodologies that appear in that regulation to deal with enforcement matters. So
The first is administrative penalties. So administrative penalties, for those that are unfamiliar with that term, exist in the environmental domain and are effectively smaller amounts that are imposed on parties who are non-compliant. It's a technique that's often used where the non-compliance is really an administrative matter that doesn't have any real significance. And in those situations, the government can come along, in this case, it's going to be the authority, can come along and say, you were supposed to submit the following report and you submitted it, 5 days late, and we're going to impose an administrative penalty on you. And those are going to be small amounts. It's extremely difficult to challenge the imposition of administrative penalties. There are some means of doing it, but it is quite difficult. But that will be one form. The second form will be orders. There's always orders that are available to the authority to essentially say, we don't think you've done what you're supposed to do, or we don't think you've met the requirements that you're supposed to meet. So we're going to order you to do something. And then the third and probably most concerning enforcement mechanism is charges. So if you are not compliant with a section of the WEEE reg, you are effectively in breach of the regulation. And when you are in breach of the regulation, what happens is that you have committed a quote offense or an alleged offense. And the regulator can lay charges for that offense. And it proceeds much in the way any criminal or quasi-criminal matter would proceed. So charges would be laid, the matter would go to court. It is actually before the courts, it's not just before the authority. And there would be either an ability to defend yourself through a trial, or there would be plea bargaining we talk about, or negotiations with the authority to try and reduce the penalty that they're seeking. And you would go before the courts in order to have the penalty or the trial heard. This is very important because of the following. When you go before the court to have a penalty imposed, before a judge or before a justice of the peace, when you do that, that is considered to be a conviction of an offense. And the company will then have a record of non-compliance. And so it is not like an administrative penalty where you just pay a fine. It's not like an order where you get told to do something and you just do it. If you end up with an offense and a charge being laid against you for non-compliance with the act, if you end up in trial and you're acquitted because you defend yourself successfully, wonderful. If you don't, you will end up with a conviction against you. And if you plea bargain to come up with a particular fine, you will also end up with a conviction against you. And the convictions mean that, again, you have a record. So it's a corporate offender record. But it also means that you're subject to much higher penalties than the administrative penalties. So for example, for a corporation that commits an offense under this legislation, the maximum penalty per count is $250,000. So that means if they found 2 breaches and they laid 2 charges, the maximum exposure you have is $500,000. If it's your second offense or higher, in other words, you already have 1 conviction, then the maximum penalty for a single offense is $500,000. So again, in my example, where 2 charges are laid because there were 2 breaches found of the legislation, your maximum exposure in that case would be $1 million with respect to those 2 breaches because you have a prior offense, which again emphasizes why I said earlier, the importance of having a conviction on record is huge, because it means you're automatically bumped up into the next category if you have another infraction and another charge is laid by the regulator. So that's very important. And the final piece I'll mention before I turn it back to Mark is, under this legislation, like most environmental legislation, there is director and officer liability. And so what that means is that any directors and officers of corporations that are found to have engaged in conduct that is non-compliant under this legislation could also be charged personally with a violation of the legislation. And like the corporation, they would have the ability to defend themselves. But at the end of the day, if convicted, that is a personal charge against the individual as a director and officer. And that has huge implications. So there's every reason to comply and to make efforts to comply. And I'll say one final thing about it, maybe two final things about it. One is that there is a defense to every regulatory charge of due diligence. Due diligence is that the company or the director and officer took every precaution reasonable to try and comply with the legislation. That is very important because as you work your way through this legislation and its complexities, making sure that you keep good records and that you do make every effort to comply will be very important if there's ever an instance of non-compliance, because it will enable lawyers like me who are trying to defend the particular charge to be able to say, here's all of the things the company did to try and make sure it was compliant with the requirements. And even if there was a breach or a violation, they truly tried to do everything they could to be compliant. So keep good records and make every effort to comply. And then the last thing I'll say is there's a provision in this legislation that you also should be aware of that says that if you end up being convicted of an offense, in addition to imposing the penalties that I spoke of earlier, they can also impose an order, which some people call profit stripping orders. Profit stripping orders are essentially where they look at any profits that you gained by failing to comply with the requirements of the statute. And if they found that you made certain amount of profits because of the non-compliance, they can require you to give up those profits. So, in an example, if they looked at the issue of the non-compliance and determined that you saved $1 million by not complying, they can ask for a profit stripping order where they can get that $1 million as an additional penalty to take away the profit that was gained. So enforcement is an important question. There are a lot of concerns with it because of the severity, particularly of that last category I talked about. And so people will want to make sure that they're doing whatever they can to be sure they're compliant. And I'll stop there and turn things back to Mark.
Thank you, Roz. Next question is, are the collection sites required to accept the material from anyone, i.e. residential, commercial, industry?
Yeah, so that will depend on the nature of the collection site and the way that it's been set up. For example, if you had a situation where you had a retail location where you were going to have a collection site available, as you saw on the slide that I had, the collection site need not make itself available for every single type of ITTAV that's sold by that particular producer. And also, for example, if that producer sold products from that location for only residential or consumer use, not for other purposes, it would not have an obligation to receive it back at that particular collection site. So in order to determine what you actually have to have, first you'd have to determine, do you fall into the large producer category or the small producer category? And once you determine which one of the two you're in, then you would have to look at the collection sites that are required to be maintained to satisfy the requirements of the regulation. And then you would decide what it has to receive. But bear in mind, as I said in one of the very first slides, this whole scheme has been intended to ensure that producers have to deal with WEEE from all types of sectors, right? Whether it's commercial, industrial, hospitals, whatever the sector might be, they are required to deal with all of the ITTAV that they produce as a producer. So if you are a producer that produces WEEE that goes into sectors that are widespread, you will have to have collection sites that are similarly widespread. You will have to make provision for everything that you produce and that you sell and market into Ontario.
Okay, thank you, Rosalind. The next question is, under the old WEEE legislation, we had a system as a manufacturer where dealers could be self-remitters as they remitted echo fees directly to the OES. Can we refuse to allow self-remitters under this WEEE?
Yeah. So the entire scheme now is different than it was under what I call the WEEE. Under the WEEE, the requirements, and many of you are familiar with, what people term as eco taxes, some people call them, but whenever you would buy electrical or electronic equipment, oftentimes there was a surcharge imposed that was intended to deal with disposal costs associated with a particular product that was being purchased. And there were lots of ways and mechanisms that could be dealt with under the previous regulation. And all of that has changed now. That is not in place anymore. At this point in time, it's either the producer that will have to deal with the costing and deal with the issues based on the weights that we talked about earlier, or they'll be able to enter into third-party agreements with service providers that will handle all of that. And so you will have to take the previous system that you may have had in place and you may have been relying on for years and try and fit that into this new system and within the framework of the new requirements. So I know I've had a lot of questions in the past on this about how existing systems can be transitioned into the new system. There aren't a lot of similarities between the two systems. It operates quite differently and it's a whole new registration system. So you will have to deal with it fresh.
Okay, thank you, Rosalind. The next question has to do with retailing online. As a producer, how do we treat equipment which retails online and is shipped outside of Ontario, or a retailer who's located outside of Ontario, but ships to a customer within Ontario?
Yeah, so those are very good questions, and I'm smiling because they're questions that I get all the time on this regulation, which is the question about materials coming into the province and exiting the province, and the fact that, the provincial border doesn't always reflect the way things are actually working in practice out there. And so the idea behind this regulation, of course, is to capture materials that are sold or used within Ontario. That's the idea behind it, is really to focus on Ontario. So you would have to look at the specific circumstances of what you're doing. But if you're an online retailer and you are selling materials that are ultimately going to be delivered into another province, you would have to do an analysis to see what the mechanism is of how it's sold, where the consumer is actually located, where the material will be sent, to see whether or not it is the other jurisdiction's waste system and regime that will apply versus our waste system and regime. Having said that, if your online retail system involves ITTAV coming into the province or being sold within the province, that is really the scope of what this regulation is all about. It's trying to ensure that you capture those materials and that you ensure that you are dealing with them appropriately within the province. So there is a guideline out there, and I'm sure this will help with some of the questions that we won't get to, but there is a guideline out there that the authority has put out, which I found and I think is very helpful, including some Q&As for assisting producers in trying to understand and to try and answer some of these questions where the circumstances don't fall precisely within the framework of what is envisioned when you look at the general terms of the legislation. So I would encourage people to look at that, but also to reach out to the authority if there's any confusion again about whether something falls within or falls without. I think in this case, because of the consequences of non-compliance, it is more important than ever to ensure that there is clarity. And oftentimes we hesitate to reach out to the regulator to ask them questions. But in the case of this regulation, I think it's better to seek the clarification and be sure you're dealing with it appropriately rather than find yourself in enforcement proceedings because they take a contrary view.
Okay, last question with 2 minutes left. It's kind of a technical one. What happens if the collection networks of the PROs collectively collect more than the collective management obligations of the producers? The MO target is 55% in the regs, but this may be too low.
Yeah, that's an interesting question. Again, it is a target, and I think the government and those that were involved in creating this legislation would be pleased, particularly in the first year, if they saw a number that exceeded 55. They would be very, very pleased with that. So I think that would just show that the program has been extraordinarily effective. Although I will say there was a lot of debate over these numbers and how aggressive it should be at the outset, whether there should be this phase-in best efforts period, and when the higher amounts would come into play. But I think at the end of the day, if those numbers are higher, I think that the authority will probably be very happy with that result and know that all of the other numbers that have been set out for the future years and the increase by 5% in performance every year would likely be achievable, which I think would probably be a very positive thing.
Great. Well, thank you. All the questions are answered and we're right at 1 o'clock pretty well.
Perfect.